Hello, and welcome to CFSS TV. I'm Ron Weber, here with Mohammed Fahim, our CEO, and he's going to introduce our special guest for this session.
Thank you, Ron. Guest tonight in this session is Mr. Alan Kaplan from the law firm of Massoud F&I, Eifert and Mitchell. And Alan specializes in employment law from the management side, if my understanding is correct. Alan, welcome to CFSS.
Thank you for inviting me.
Tell me a little bit about the law firm and what do you guys do? How long have you been in business? How do you impact your clients?
Well, we've been in business since 1929.
Whoa,
Founded
a little
by,
bit before my time.
Founded by Japanese Americans. So our specialty is representing foreign corporations and their American subsidiaries from Japan, from Europe, from India, and helping the American subsidiaries begin, grow, and succeed in the United States. We also represent small to mid-sized American-owned companies in the Chicago metropolitan area. As I said, we're a full-service business law firm. So we do everything from mergers and acquisitions, real estate, construction, contracts for real estate, to employment, trademark, litigation, and beyond.
Wonderful. Thank you. Our focus today, though, is going to be on managing risks for employers. What do you as an employer need to know when you are hiring someone, you're firing someone? What are the risk factors and how do you manage that? With that, Alan, let's get the ball rolling. What is the basis for termination now if you want to terminate somebody?
Well, there are three basic reasons why employees are terminated.
Okay.
And the three reasons are misconduct by an employee, poor performance, or an economic reason that a company may have.
Okay. So when we are talking about misconduct, I believe it's a violation of some rule that the employer has put. Does that rule have to be in writing, and should the employee be made aware of that, during the onboarding process? How critical is that?
Well, it's very critical that, one, there be rules. Two, that they be in writing to the extent you can put them in writing. Not every rule can be in writing. Some rules are self-evident. For example, employees should not be sleeping on the job.
Okay.
Should that rule be in writing?
But if they are working in a mattress company, okay.
Okay. As part of testing the product, of course. But yes, but rules in general should be in writing. The most important rules should be in writing. They should be known to the employees. So really, there's a process for misconduct, and that there's a rule, that it is known by the employee, that the employee may have violated that rule, that the violation, supposed violation, is investigated, and there's a decision that the employee then violated that rule, and then discipline results. And then the question becomes, what is the appropriate discipline? Is it a warning, is it a suspension, or is it termination? So companies have to go through that process. The reason companies should go through that process is risk management. Risk management is the ability to figure out what is the basis for losing a lawsuit, for protecting the company from a lawsuit. And we need to manage risk as lawyers, as management in a company.
Following up on that, I got another question for you. When you say that the employee needs to be made aware of that rule, and say someone has been there for 20 years, and when they were onboarded, they've forgotten most of the rules, and maybe the rules may have changed. How important is it to keep up, updated training sessions and all of that, both from the employee and the manager side?
Yeah, it's very important. And companies have different procedures for updating employees, for keeping employees aware. I, for one, recommend that my clients meet once a year with the employees and reintroduce important policies to the employees. For example, the anti-harassment policy should be introduced to employees every year and to supervisors every year. Basic policies probably should be told to the employees and to the supervisors every year. The company has to decide what's important and what's not important. what
Okay.
is worth fighting about, what's not worth fighting about,
Okay.
and really analyze what their issues have been the prior year when they are going to be talking to the employees the next year.
So folks, the important point that Alan is trying to get across is the training has to be on an updated basis annually, if possible, not just for the employee, but for the supervisor who is directly supervising that employee. And let's face it, things change, supervisors change, and the next one comes in and terminates somebody, and then there's a lawsuit on your hands because they didn't follow procedure.
That's right. And it's very important for every company to have a procedure, to understand who is the decision maker.
Okay.
What is the decision-making process? We have situations in many companies in the United States where there is a human resource professional, but then the human resource professional is ignored by a manager when the
Okay.
manager is making a decision. So there needs to be a procedure, and the president, the C-level suite people need to set forth that procedure, make sure it's followed by all the managers and employees within the company.
Alan, is the employee in a protected group?
Yes, I would say all employees are in a protected group. And as we do risk management, one of the things we try to decide are what protected classifications employees fall, because that would give them a hook in which to sue the company.
Define protected groups now for me.
Well,
What are the most obvious protected groups?
Yeah, a protected group is a group that has been set forth either in writing by a statute, by a legislature, either federal, state, or local.
Okay, Title VII, for example.
That's right.
Yeah.
Title VII is the statute from 1964, amended since at the federal level, that protects employees of race, religion, national origin, sex, and then there's also state laws. There's
Okay.
the Illinois Human Rights Act, for example, in Illinois, which protects those classifications as well as other classifications. So, for example, employees of sexual orientation are not protected at the federal level, but are protected at the Illinois Human Rights Act level, along with the Cook County Human Rights Ordinance and the City of Chicago Human Rights
Wow.
Ordinance. So companies need to be
So
aware.
a lot of lawyers writing these rules making money. Is that what you're telling me?
Well, I don't want to go that far. But what happens, and as you know, we have a democracy, a representative democracy.
know.
So employee groups approach legislatures and
Okay.
say, we need to be protected.
Okay.
So the protected classifications then grow according to the interest groups of
That
the
are-
employees.
That are lobbying for those protections. Great information so far, folks. So please keep tuned to cfss.us. That's our website. So www.cfss.us, and you're welcome to visit the website. It's absolutely free information. Sign up for our newsletter. Again, it's a free newsletter, and we'll send you updated information on coming guests, the coming questions, and if you have any questions that you want answered, you can always reach out to us through the website also. So continuing the conversation now, Alan, Ron, do you have another question that you want to ask?
Are there written or oral employment agreements?
Yes, yes. Many employees will have written agreements. So whenever you're going to make a decision regarding an employee's status,
Okay.
there may be written agreements, written promises that have been made by the employer to the company.
Okay.
I'll give you a perfect example of a bank I represented here in the Chicago area, and they brought in a minority person as a vice president,
Okay.
and he alleged that he was promised stock options. When we took his deposition, I asked him exactly, well, what did the president of the bank tell you about the stock options? And he responded in his deposition, well, the president said that if we have an enlarged bank, if we grow,
Okay.
there will be stock options. Well, an if is a contingent. That's
Okay.
not the word will. You
Okay.
will have stock options. So what is a contract? So yes, written agreements can be created between companies and employees. Oral contracts can be created between companies and employees. So when a company is trying to decide what type of action to take with an employee, you have to do the risk analysis. What
Okay.
protected classification are they in? What written or oral agreements apply to that employee?
Okay, so from an employer's point of view now, it is always better to be prepared, be aware of potential risks, rather than running straight into it and then coming to the attorney, right?
That is correct. One mistake, one decision can cost a company $500,000.
Wow.
If you have more than 100 employees and you terminate an employee who's in a protected classification, that's punitive damages of $300,000. That's attorney's
Wow.
fees. That's attorney's fees to the employee's lawyer, $100,000. Back pay,
Whoa.
let's say $50,000 a year. It takes 2 years to get to trial. It's another $100,000. We're already at $500,000 without pain and suffering, emotional distress, and the fee that the company has to pay to their lawyer to represent them even when they lose. In the United States, as you know, it's not the loser who pays the other side, as in England.
Okay.
Each side pays for themselves. So I always say that one 15-minute phone call to a lawyer, to an HR consultant,
Okay.
to someone who has knowledge
Okay.
can save a company a lot of money.
Wonderful. Folks, again, our guest in the studio today is Mr. Alan Kaplan from the law firm of Masuda Funai, Eifert, and Mitchell, a full-service law firm. Alan's specialty is employment law management side. And if you have any questions that you would like answered, I will put together an information package about Alan and his firm on our website. You can, reach out to them by email or, go to their website and reach out to them also. So, Alan, let me ask you this. If one of our listeners, viewers, employers want to reach out, initial consultations and all of that, they can always call you guys up and at least get a feel for, what they're getting into and what the cost would be involved, right?
Of course, of course. We have a free monthly newsletter, which you could sign up for at www.masudafunai.com. And as you know, once you sign up for the newsletter, you are invited to our free webinars and to our free annual seminars. You attended our immigration seminar.
And I attend the webinars also, and I am on your newsletter list. And wonderful information. Again, this is coming straight from experts. This is not, my neighbor Ron Weber over here telling me about what is changing in the employment law field, right? So you may have the best friends and good family members who are trying to tell you what things are happening. Please talk to a professional before you end up with trouble, especially as an employer, and you need to know what the rules are. So let's continue this conversation. Is there a written or oral employment agreement that employers, is there kind of like a, for lack of a better word, is there pro forma, or that thing differ from employee to employee, situation to situation?
It's very interesting because every company likes to do an offer letter
Okay.
to newly hired employees.
Okay.
What is an offer letter? An offer letter could be a contract. For example, does the offer letter say that you will be permanently employed? That's a very interesting word, permanent. Is that a will statement for permanency? Does that mean to the court that you could only be terminated for cause and that you're
Okay.
not an at-will employee?
So the at-will, thing that is here in Illinois, that, they can let you go for any reason, no reason whatsoever. If the offer letter uses the word permanent, then there might be an issue with that, right? Wow, what a concept. Okay.
There could be a problem with that. Offer letters also will include information about salaries. It may even include information about oral promises. So what we've seen now is that plaintiff lawyers are becoming more creative.
Okay.
If an offer letter does not specifically disclaim oral agreements,
Okay.
a lawyer can say there was an oral agreement to give a raise. So we need to now have language in offer letters saying that this offer letter supersedes all previous written and oral agreements that may have been made. So even the simple offer letter that all companies use
Right.
can be very dangerous and needs to be looked at. I always recommend that every company do an audit of their employment procedures. from
Okay.
beginning to end, from onboarding and even before onboarding, from advertising and determining whether or not you need a company, all the way to the termination of the employee. What does that audit trail show?
Okay.
Are you in compliance with the laws from beginning to end? Are you doing risk management from beginning to end to protect the company? Because what's most important for a company is being productive
Right,
and growing that company, being successful.
right.
And it's been very sad what I've seen, because when you pay a lawyer, that's an expense that is not on the balance sheet.
Right.
It's not in the budget. It's off budget. That's
Huh.
a tremendous burden on a company to have an off-budget expense of tens of thousands
Of
of
tens of
dollars.
thousands of dollars. And that's where the importance of talking to professionals before you end up in problems comes in, folks. Again, our guest today is Alan Kaplan from the law firm of Mr. F&I, Eifert and Mitchell, a local Chicago firm, I believe. And you have offices in Schaumburg and Chicago, right?
And in Los Angeles as well.
Wonderful. Ron, continuing the conversation, sitting with me is Ron Weber, our Executive Vice President of Business Development for CFSS. Ron is developing a fan following now with these TV programs. Go ahead, please.
Alan, has the employee exercised a legal right recently?
Well, that's another question to ask for risk management. What are legal rights that employees can exercise? For example, if an employee falls and injures themselves in the workplace, they
Okay.
can file a workers' compensation claim. Or the company can be afraid that they will file a workers' compensation claim. That is a legal right, and employees cannot be retaliated for doing and exercising that right. If an employee contacts, I'll give you an example.
Okay.
An employee is worried about an oxygen tank that's
Okay.
in a nursing home, and that employee contacts the local fire department because they're afraid that that oxygen tank will blow up.
Okay.
By contacting the local fire department and having that local fire department come in, that's a protected activity
So
by
it's
that
not
employee.
kind of like it's a whistleblower kind of things also, right? Same protections?
Exactly.
Okay.
These are whistleblower activities by employees.
Right.
And these whistleblower activities can be, again, set forth by statute or created by judges in
Okay.
court cases.
Let me ask you something as a quick follow-up on that. Let's say that I am an employee and I fall down, I get injured, and I just let it go. Okay, I don't do anything about it. And now, does that mean that I am letting go of my legal right in that situation?
Yes.
Because the second time I fall down and I get injured, and my manager would come and say, "Well, the last time it happened, you never did anything. So what's with you today?"
Well, the issue with workers' compensation is that, yes, all these injuries should be reported as soon as possible.
Okay.
The insurance companies will investigate workers' compensation claims.
Okay.
And they will determine whether or not the claims are legitimate. So if someone injures themselves over the weekend moving furniture, shows up Monday morning and injures themselves at the workplace, was the injury from the moving the furniture or from
Or the
the
workplace, yeah.
lifting the 25-pound engine on the assembly line? So employees need to report their injuries. Companies need to have a process, a procedure of
Okay.
investigating injuries and then following through with the workers'
And of
compensation.
course, they have to document all of these things, right? Documentation is extremely important, folks. I've run into employers who don't document stuff, and then they're calling us up for, advice on that. I mean, I am not an attorney. CFSS is not a legal firm, but we could refer you to the proper attorneys and the proper resources. In case you have any need, feel free to get in touch with us. We will be more than happy to connect you with the right resources.
Alan, should the company seek a release from the employee?
That depends. What is a release? A release is a written agreement between the employee and the company in which the employee agrees that they will not sue the company for the
Okay.
termination or for any adverse action that took place against the employee.
Okay.
So again, it's a way to manage risk to have employees sign these agreements. I represent a company in a far western suburb that went through 4 different reductions in force.
Okay.
They went from 250 to 50 employees. Wow. They did not have one lawsuit over that 4-year period of time. They did not give one release to employees. They gave 2 weeks' pay to every employee as they left. They decided that if we give releases, written agreements to employees, that may get the employees thinking about, do I have any legal claims? What is the company afraid of, that they're giving me this legal document? And of course, in that situation, the employees realized that the company was losing money, and I'm next. So it all was legitimate reductions in force. It's a lot different situation than an employee who is in 4 or 5 protected classifications, where you don't have the documentation for the discipline, for the poor performance, where the past evaluations were always a 5, 1 out of 5, and no one likes to give a bad evaluation, but you know, a month after the evaluation with a 5, the supervisor comes to HR and says, I've never liked that employee, and that employee is over 40, Hispanic, disabled, etc. That might be a situation where there's higher risk, and you may want to get a release from that employee. In exchange for the release, give that employee some money.
So folks, it's very important that you get the right legal advice when you are in business. Everybody is in business to make a difference, make a profit. It does not make sense to cut down on stuff and then you get hit on the back end very heavy, like you said, what, 300,000 at a minimum for discrimination and all of those if you're found guilty?
As a possibility. As a possibility.
So you talked a little bit about the Illinois Department of Human Rights.
Yes.
What is that organization?
Well, it's a state agency.
Okay.
And there are offices in Chicago and Springfield, and employees can go to that agency and file a charge against a company for an action that was taken against the company, taken against the employee by the company.
How does that differ from the EEOC?
Well, it's the state agency as opposed to the federal agency.
Okay.
So when you file a charge at the Department of Human Rights, Illinois, the Illinois Department of Human Rights will investigate that charge. If you file the charge at the EEOC will file the charge.
Is that kind of like state law and federal law, that federal law, supersedes state law, or is that different?
Well, you're right. There is a legal doctrine of preemption, where if there's a federal law, it preempts state law. In this type of situation, though, discrimination, you can have state and federal agencies working at the same time.
Wonderful. Again, thank you very much. Our guest today has been Alan Kaplan from the law firm of Masuda Fanai, Eifert and Mitchell. I'm Mohammed Fahim with the Center for Strategic Solutions. With me is Ron Weber with the Center for Strategic Solutions. Our producer today has been Mr. John Runyon, and he is the producer and the director also for these programs. And Alan, thank you very much for coming on as a guest. Really appreciate your time and your expertise. If you need more information, folks, would you mind giving your website again?
Yes, it's www.masudafunai.com.
Thank you very much, Alan. Appreciate it.